It sometimes feels like certain people in government do not actually understand how the government itself works, and honestly, it makes you wonder how some of them even made it to Congress in the first place. So, Mr. Wu, I'm going to ask you a few basic questions because I'm not completely confident that everyone else in the room actually knows the answers. Let's start with something simple. How many branches of government do we have? 3. Right, 3. And can you name them for me? Legislative, judicial, and executive. Exactly. That's correct. Now, as far as I'm aware, I currently serve in the legislative branch of the United States government. Would you agree with that? Yes, good. Now let me ask another question. When someone goes through a criminal trial, for example, when a person is convicted on multiple felony counts in a state court like the one in New York, which branch of government is responsible for handling that process? Would that be the legislative branch or would it be the judicial branch? Technically, the executive branch brings the prosecution, but the trial itself is carried out within the judicial system. Right? So the judicial branch is where the case is actually handled. Now, typically, if someone believes something went wrong during a trial or they disagree with the verdict, do they jump from a state court straight into the federal legislative branch to complain about it? Or is there a specific legal process they are supposed to follow? There is a process. That would be the judicial appeals process. Exactly. That's how it works. So normally, when someone is convicted in a state court, they do not suddenly appear in Congress trying to relitigate the case in front of lawmakers. Instead, they go through the appeals courts within the judicial system. So normally, when someone is convicted at the state level, they don't suddenly jump over to the federal legislative branch to argue their case. That simply isn't how the system works. There is a clear legal path that people follow through the courts. That's why what's happening here feels a little unusual, almost like we're living in the upside down for a moment. But let's keep going and talk about how a criminal prosecution actually begins in the first place. Right now, under our current legal system, when someone is prosecuted for a crime, is it the President of the United States who personally acts as the state prosecutor in a place like New York? Absolutely not. Exactly. The president is part of the executive branch at the federal level, and that role has nothing to do with acting as a state prosecutor in a local criminal case. In this particular situation, the prosecutor involved was Alvin Bragg, who is the district attorney in New York. And just to be clear, he wasn't appointed by the president, he was elected by the people who live in his jurisdiction. So he is a duly elected prosecutor chosen by the citizens in that area. Now, before any criminal case ever reaches a courtroom, there is typically an investigation that takes place. Law enforcement and prosecutors review the evidence, gather information, and determine whether a crime may have been committed. After that investigation is completed, the prosecutor has what we call prosecutorial discretion. That means they have the authority to decide whether there is enough evidence and legal justification to move forward with charges. If they believe the case should proceed, the next step, especially when we are talking about felony charges that could result in more than a year of prison time, is to present the case to a grand jury. A grand jury is made up of ordinary citizens from the community. These are not politicians, not government officials, just regular people selected from that jurisdiction. Their role is to review the evidence presented by the prosecutor and determine whether there is probable cause to believe a crime was committed. If they agree, they issue what is called a true bill, which means the defendant is formally indicted and the case moves forward to trial. Once an indictment is issued, the case moves into the pre-trial phase. During this stage, there are a number of legal procedures that take place before the trial even begins. Attorneys on both sides file motions. The court may hold hearings, evidence is reviewed, and various legal arguments are made about what should or should not be allowed during the trial. All of this is a normal part of the judicial process and happens in virtually every criminal case. Eventually, the case reaches the trial itself. At that point, the defendant has the right to request a jury trial. In the United States, that jury is made up of ordinary citizens, people from the same community, who are selected to listen to the evidence presented by both sides. The defendant is also entitled to legal representation, meaning they have the right to an attorney who can defend them, challenge the prosecution's arguments, present evidence, and help select the jury that will ultimately hear the case. During the trial, both the prosecution and the defense present their arguments, call witnesses, and introduce evidence. The judge oversees the proceedings to make sure the rules of law and procedure are followed, but the judge does not decide whether the defendant is guilty or not guilty in a jury trial. That responsibility belongs entirely to the jury. The jury listens to all of the evidence and arguments, and then they deliberate privately before reaching a verdict. In this particular case in New York, after the trial process was completed and the jury had reviewed everything presented to them, they returned with a verdict. They found the defendant guilty not once, not twice, not 3 or 4 times, but on 34 separate counts. So the decision did not come from politicians, commentators, or people outside the courtroom. It came from a jury of citizens who were selected to evaluate the evidence and make that determination according to the law. And that is the key point. In the United States, criminal guilt is not determined by political opinions or by people debating the case on television. It is determined by a jury. That jury is made up of ordinary citizens who listen to the evidence presented in court and decide the outcome based on the law. In this case, those jurors reach their decision after going through the full legal process. If someone disagrees with that outcome, there is still a system in place to address it. The next step is not to take the argument to Congress or to try to relitigate the case in a political hearing room. The proper path is the appeals process within the judicial system. A defendant can go to an appellate court and argue that legal errors occurred during the trial, and those judges will review the case and make a determination. That's how the system is designed to work. The courts handle criminal cases, juries determine guilt, and appellate courts review decisions if there are concerns about how the trial was conducted. The legislative branch does not step in to redo criminal trials or overturn jury verdicts simply because some people disagree with the outcome. So what happened in that hearing room was actually very simple. The entire situation was walked through step by step, starting from the basic structure of government and moving all the way through the criminal justice process. Each question highlighted how the system functions and who is responsible for each part of it. By the end of that exchange, the message was clear. When you understand the facts and the structure of the legal system, you don't need to shout or argue. You simply explain the process, ask the right questions, and let the facts speak for themselves.